right, the jury is present. The state has rested its case at this time. Does the defense also rest its case at this time?
The defense rests, Judge.
Ladies and gentlemen of the jury, both sides have now rested their case. What we would normally do at this time is do the closing arguments, and then I would conclude the trial with the jury instructions and have you deliberate. We're going to depart from that and use an alternate procedure, which is perfectly fine and legal and perhaps better for the situation. What I'm going to do at this time is instruct you on the law as agreed upon by the lawyers, and then they're going to make their closing arguments to you tomorrow morning, after which you'll begin to deliberate on the case. The advantage of this is you'll have heard the law already as an advantage to your understanding their arguments to put it into context. But please remember something I instructed you on throughout the trial, which is do not form a definite or fixed opinion on the merits of the case until you've heard all of the evidence, the arguments by the attorneys, and the law as I instruct you. And it was stated in that sequence because that's normally the sequence. So you're going to hear the law, but don't form any definite or fixed opinion until you've heard the attorney's arguments tomorrow. And of course, until the time I send you back into the jury room, don't discuss the case with anyone, including your fellow jurors. I suppose what I'm saying is the fact that I'm going to instruct you on the law now is not an invitation to start your deliberations, which are actually mentioned in the instructions. That you don't start your deliberations until tomorrow after the attorneys make their final arguments to you. Also, I'm going to be reading the instructions to you. Tomorrow, after the arguments are made, these instructions will go back with you into the jury room, and I'll have a copy for each of you individually for you to refer to should you need further reference to the instructions during your deliberations. And members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Jose Soto-Escalera, the defendant in this case, has been accused of the following crimes. Count 1, first-degree murder with a weapon. Count 2, first-degree murder of an unborn child. Introduction to homicide. Jose Soto-Escalera is accused of first-degree murder in counts 1 and 2. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Tanya Wise and her unborn child were killed by Jose Soto-Escalera, you will then consider the circumstances surrounding the killing in deciding if the killings were first-degree murder or second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. I now instruct you on the circumstances that must be proved before Jose Soto-Escalera may be found guilty of first-degree murder with a weapon, first-degree murder of an unborn child, or any lesser included crime. Count 1, first-degree murder. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Tanya Weiss is dead. 2, the death was caused by the criminal act of Jose Soto-Escalera. And 3, there was a premeditated killing of Tanya Weiss. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether Jose Soto-Escalera did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death. And Jose Soto-Escalera was in fact so provoked and did not cool off before he committed the act that caused the death of Tanya Weiss. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should not find him guilty of first-degree premeditated murder. If you find that Jose Soto-Escalera committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of first-degree murder with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto-Escalera committed first-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of first-degree murder. Count 2, first-degree murder of an unborn child. To prove the crime of first-degree murder of an unborn child, the state must prove the following two elements beyond a reasonable doubt. 1, Jose Soto-Escalera caused the death of the unborn child of Tanya Wise by killing Tanya Wise. And 2, Jose Soto-Escalera's killing of Tanya Wise was first-degree murder, as I have instructed you in count 1. Unborn child means a member of the species Homo sapiens at any stage of development who is carried in the womb. When there are lesser included crimes, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which Jose Soto-Escalera is accused, there may be evidence that the defendant committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crimes of first-degree murder with a weapon are second-degree murder and manslaughter. The lesser included crimes of first-degree murder of an unborn child are second-degree murder of an unborn child and manslaughter of an unborn child. Second-degree murder, a lesser included offense as to count 1. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Tanya Weiss is dead. 2, the death was caused by the criminal act of Jose Soto-Escalera. And 3, there was an unlawful killing of Tanya Weiss by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Jose Soto-Escalera did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death, and Jose Soto-Escalera was in fact so provoked and did not cool off before he committed the act that caused the death of Tanya Wise. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should not find him guilty of second-degree murder. If you find that Jose Soto-Escalera committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of second-degree murder with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto-Escalera committed second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of second-degree murder. Manslaughter, a lesser included offense as to count 1. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Tanya Weiss is dead. And 2, Jose Soto-Escalera intentionally committed an act or acts that caused the death of Tanya Weiss. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Jose Soto-Escalera committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of manslaughter with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto-Escalera committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of manslaughter. Second-degree murder of an unborn child, a lesser included offense as to count 2. To prove the crime of second-degree murder of an unborn child, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jose Soto-Escalera caused the death of the unborn child of Tanya Weiss by killing Tanya Weiss. And 2, Jose Soto-Escalera's killing of Tanya Weiss was second-degree murder, as I have instructed you in count 1. Manslaughter of an unborn child, also a lesser included offense as to count 2. To prove the crime of manslaughter of an unborn child, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jose Soto-Escalera caused the death of the unborn child of Tanya Weiss by killing Tanya Weiss. And 2, Jose Soto-Escalera's killing of Tanya Weiss was manslaughter, as I have instructed you in count 1. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant not testifying. The Constitution requires the state to prove its accusations against the defendant, it is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, whether, when the defendant made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. And counsel, I'm striking that next sentence in this particular case. Whatever verdict you render, start over with that sentence. Little tongue twisters here. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proved beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. And tomorrow, after the arguments, I will show you the verdict form and explain it to you before I send it back with you for your use. Single defendant, multiple counts. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. The last instruction is submitting the case to the jury, which I'm going to do with you tomorrow. So after the arguments are concluded, I'm going to reread to you the few of the last pages here before I submit the case to you. That concludes the instructions at this time. Tomorrow we will reconvene at 8:45 in the morning, just as we did today. Remember, I cannot overly emphasize, you have not heard the arguments of the attorneys. Don't form any definite or fixed opinion about the merits of this case at this time. The same rules that govern your conduct remain in effect. Of course, in abundance of caution, please remember, avoid any exposure to any extrajudicial information. Don't talk to anyone. Don't do any research about the case or the people or the issues involved in the case. To be sure, you confine your consideration of this case only to the proper evidence and nothing else. Avoid all of the media coverage of this case. With that, enjoy the rest of your day and your evening, and we'll see you tomorrow morning. Please leave your notes on your chairs. Jury has exited. Before we break, let's take a look at the verdict form as well, just to be sure there's no objections to that. Oh yeah, I wanted to take out the form as to count 2. The state had put in a weapon, which doesn't apply to count 2, so I'm going to take that out. Okay. You remember that? Okay. And I also put unborn child in the language as to count 2, which fits the charge. It just said first-degree murder. It didn't say unborn child, so I have that as the count 2. And it is still September, so that's correct on the verdict form, right? And so right now the verdict form says what was that? We, the jury, find Jose Antonio. I'll get rid of the Antonio.
That's all right, yes.
Do that also on the top there. Verdict form. We, the jury, find Jose Soto-Escalera as to count 1, select only one, guilty of first-degree murder as charged in the indictment, guilty of second-degree murder as a lesser-included offense, guilty of manslaughter as a lesser-included offense, or not guilty. If you find the defendant guilty as charged or guilty of any of the above, there's an error there, above lesser offenses. I'm adding a word there. You must next determine if any of the following has been proved beyond a reasonable doubt. Check yes if proved beyond a reasonable doubt. Check no if not proved beyond a reasonable doubt. During the commission of the offense, the defendant did carry, display, use, threaten to use a weapon, or attempt to use any weapon, yes or no. Count 2, select only one. Guilty of first-degree murder of an unborn child as charged in the indictment. Guilty of second-degree murder of an unborn child, a lesser-included offense. Guilty of manslaughter of an unborn child, a lesser-included offense. Not guilty. So say we all. This blank day of September 2025, 4-person. So that looks good. I'll print out a few copies of that to give to you all and for myself here. And anything else before we break from the case? From the state?
My only request for tomorrow would be to have it maybe a the 5 or 10-minute bathroom break after the defense finishes their closing.
After the defense part?
Yeah.
Well, that reminds me of another issue. So what we should do for the bailiffs, take the lunch order of the jury as soon as possible, because they're going to be here for lunchtime, for sure. Are we still using roots or whatever?
Chick-fil-A, I think.
Oh, there you go. That's less offensive to the jurors than the other miserable food that we were offering them, like some kind of sprouts and something. So that's good. Let's take their order so that it's there and we get the lunch, because it's going to be right about lunchtime that we're going to submit the case to them. And as far as the bathroom break, that's perfectly fine. In fact, Miss Minton, if you want one after they get finished too, I'm just kind of giving you a wink and a nod, and we'll do that as well. All right, and if there's nothing else, how about this? Maybe this is a good time too. Check over the evidence to be absolutely sure there's nothing going back that shouldn't.
They've already locked it up.
Oh, okay.
Well, I mean, open it back over, you can look in the box, because the box is really, and it's not gonna take that long. I can pull it out.
There's not that much. It'll
Just
be-
to avoid calamity, the items that are not fully admissible, you know, that we've done those, I forget, 1/6, exactly,
170, 183.
which are not going back to the jury. But if they did, is there any request for a laptop to go back to view other stuff? There's not, so we're kind of doubly safe. Even if it goes back accidentally, they can't view it anyway, because they don't have an electronic device.
Well,
no,
I take that back. The defendant's interview.
And
The defendant's interview.
surveillance videos are going back there.
Right, so we need to
will
be
have a
extra
laptop.
cautious to make sure that those don't go back. And the other item that's not, just make sure the other items that are not into evidence do not go back into the jury room, because there's several that were marked that are not into evidence, right?
Yeah.
I'm gonna strike that. You all caught that? That was good, Johnny, on the spot. The sentence that I said was, I decide the sentence. Well, no, well, Judge, why do we spend 2 weeks in death qualification?
We're not supposed to have it in there.
Yeah, right. That was a good catch by me. I'll strike that and reprint the instructions for myself and for the jury. All right, and then we'll be adjourned until tomorrow morning at 8:45. Thank you.